Hello all, and welcome back to the.universary. Today we have two small claims cases. This first one is out of Licking County, Ohio, and was very cute. The case itself is very straightforward and short. The cute part comes at the very end when we find out that this was Judge Stansbury's first small claims case that he presided over. And it was just very fun to see his personality come forward a bit. I hope you enjoy.
All right, we're on the record now in case number 23 CVG 02958. It's captioned Village Green Management, specifically Cumberland Links Apartments, versus Hank Howard and all other occupants. Counsel for the plaintiff, Mr. Carnes, is here. The defendant has failed to appear. Mr. Carnes, is the plaintiff prepared to present evidence in support of its first cause of action?
We are, Your Honor. I have one witness today.
All right. Ma'am, if you'll go ahead and raise your right hand. Do you solemnly swear that the testimony that you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Please, for the record, state your full name.
Noelle Oliva.
And please spell your last name.
Oliva.
And please state your full business address.
130 Cumberland Way, Pataskala, Ohio, 43062.
Thank you very much. Mr. Carnes, you may proceed.
Thank you, Your Honor. Ms. Oliva, you've introduced yourself to the court. Can you tell the court your position with Village Green Management?
I'm the property manager for Cumberland Links.
Okay. And we're here today with respect to the property at 107 Sneed Road, Pataskala, Ohio, 43062. Is Village Green the duly authorized management agent for that property?
Yes, they are.
Okay. And did Hank Howard have a written lease agreement to possess that property?
Yes, he did.
Okay. I'll show you a copy of Exhibit 1 that's attached to the complaint. Do you recognize this document?
Yes.
Is this a true and correct copy of Mr. Howard's lease agreement?
It is.
And under this lease, was he required to pay monthly rent on or before the first of each month?
Yes.
Okay. And has he failed to pay his rent pursuant to this lease?
Yes.
Okay. As a result, was he served with a notice to leave the premises?
Yes, he was.
Okay, I'm showing you a copy of a notice to leave the premises that's dated October 9th of 2023. It's for non-payment of rent. Was this notice served on Mr. Howard on that date?
Yes, it was served to his door.
Okay. At the time it was served to the premises, was he behind in rent?
Yes.
Is he still behind in rent as we sit here today?
Yes, he is.
Has any rent been tendered and accepted since the service of this notice on October the 9th?
No, it hasn't.
Okay. And to the best of your knowledge, is Mr. Howard still occupying the property?
Yes, he is.
Okay. And for the court's information, can you give the court the estimated amount of the arrearage as of today?
He's in excess of $7,000.
Okay. And as a result of his continued occupancy at the premises and his failure to pay rent for some time now, you're asking the court for a judgment for a writ of restitution today?
Yes.
Okay. Your Honor, I don't have anything further. I would ask or move Exhibits 1 and 2 into evidence, and this is a single cause action, Your Honor.
All right, very well. The court will grant the motion to move plaintiff's Exhibits 1 and 2 into evidence, and the court finds that the plaintiff has met its burden of proof by preponderance of the evidence of a breach of the lease in the form of non-payment of rent. Therefore, judgment will be entered in favor of the plaintiff on this first and only cause of action, and a writ of restitution shall be issued and executed. Mr. Carnes, anything further today?
Nothing further, Your Honor.
Very well. That'll be all.
Thank you.
Thank you.
Tell me it was that easy up here.
Okay, now this second case takes up the lion's share of this video. This is before Judge Jeffrey Middleton in Michigan, and it's a small claims case where a tenant is suing her prior landlord for return of her security deposit. And this one was really interesting. We've got two conflicting stories. Both say that they've talked to the same people, and both have taken completely different conclusions from their conversations. So it's really interesting to see how Judge Middleton handles it and his ultimate decision. Let me know what you think in the comments, and I hope you enjoy.
All right, this is Cassandra Honer and Ronald Farmer versus Robin Standish. Are you Cassandra Honer?
I am.
Is Ronald Farmer with you?
He just went to go pick up the kids. He'll be back shortly.
All right. This is a claim for $2,459 for failing to return your security deposit.
Yes.
The Standishes, and Robin and Scott Standish are here. They have filed a counterclaim and a defense. And they are counterclaiming for $932.88. In their letter dated October 20th, they lay out how they came up with this and why they didn't return your security deposit. And they've attached a number of pictures to support their claim. So let's put everybody under oath. Ms. Honer, would you unmute your microphone?
Yes.
All right, Scott Standish, Robin Standish, Cassandra Honer, please raise your right hand. You all swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
Yes, Your Honor.
All right. Let me go to the complaint here. It's kind of hard to determine, but you pled failed to return security deposit for rental in timely manner, overcharged for security deposit, see attached. So there's a whole bunch of stuff attached, but for me to actually calculate how you came to that number, I had trouble. So help me out here. Why do you believe that they owe you $2,459?
Okay, Keystone paid $1,650 for a security deposit. They
All right.
then,
Give me
as
that
soon as
number again.
sorry,
$1,600.
$50, yes.
All right.
And then they turned around and charged me on top of that once Keystone stopped paying, because Keystone didn't pay the total amount that they wanted as a deposit. They charged me that as soon as Keystone stopped paying. So it was $540 on 3/16/23, and then another $269 on 3/27/23. So that is the total to make up the rest of the security deposit. Because
All right.
Keystone paid for April 1st. They were charging me in March.
All right. So how much money did you actually pay?
For security deposit, I paid $809.
That's $540 and $269.
Yes. And then I spoke to Keystone. They told me that the deposit they made was on my behalf. I get the money back. I also have papers for you from them that I can submit that I had just gotten recently, where she had wrote up a paper for you stating that if you needed anything from them, they would be more than willing to give it to you, as they can't give me much because her financials are on that. But if you would
Well,
like it, they can
so
give it to you.
Keystone, so if we add 1650 plus 809, so you want me to give you the $1,650 that Keystone paid?
That they told me that I get that back because they paid it on my behalf.
I'm not clear about that, but so that's free money for you. It wasn't your money in the first place. But
Yeah,
all right,
I
so
thought
that's
that
how we
too.
get up with that. So you believe they're entitled to none of your security deposit?
Well, the problem is I didn't hear from them for 47 days after. We reached out on 8/27 and still heard nothing back from her. When she called me after 47 days of us moving, she wanted to do another walkthrough. So she did not. The first time I saw an itemized list at all was the one that she gave to you guys on the 20th. I hadn't seen nothing before that. I was asking her, do you have an itemized list for me so I can see what damages need to be paid? I heard nothing from her. She couldn't return my texts, nothing. We also mowed her lawn after we moved out twice to help her out because she said that her mower had broken.
All right, now I don't have the lease.
Yeah, I didn't
Probably
submit.
have it in the
Sorry.
landlord tenant case. But I don't have the lease in this case. Now, Miss Standish, you provided this letter and you said this is not a deposit.
Correct.
So you're saying that Keystone paid $1,650 as a non-refundable cleaning fee and last month's rent.
Your Honor, Keystone actually emailed me one and I just received it as well. So they went according to the lease. The lease states that they had to pay the first and last month's rent. Well, the first month's rent, they asked me if she could move it in early, leaving, which was February 22nd. So they prorated it, and it is on the check stub with her filing on page 3 of her filing is a breakdown of how the Keystone came up with that money. And if you count the first page where it's got the court case number on it, it would be the fourth page. And it's a check stub from Keystone. Do you see that?
No.
There's a check number 19244 in the top right-hand corner.
All right, I see that.
Okay, so the 1650 that they marked as SD, when I called her, I said, you had me waive the security deposit because she didn't qualify for the amount that we were renting. So we actually reduced the rent to $1,100 a month. And I just scanned the lease trying to send it to you, but something aired out. I did send her a copy of the lease and I texted it to her. And on the 1650 equals $1,100 for the first or last month's rent. And the first month's rent was $196.45, letting her in on the 22nd of February. And the $500 on the first page of the lease that we just scanned is a non-refundable move-in fee. Or yeah, it's a non-refundable cleaning fee. So it's in the lease, the actual lease, and initialed by all of us.
Well, obviously, I can't see that. Let me
Right.
see if there was a landlord-tenant case. Was there a landlord-tenant case?
No.
So I don't have a copy of the lease, so I'm fumbling in the dark.
Okay, so $1,100 was last month's rent, and the $500 non-refundable move-in fee.
All right, now let me ask you
sorry.
another question.
Yes.
You've got obligations on under the Landlord-Tenant Relationship Act. And when she moves and turns in the keys within 42 days of her moving, you're supposed to send her an accounting of what she owes. So when did she move out?
She actually texted us and sent us actually didn't send it. They dropped off a letter that said they had a 7-day notice to quit. And I explained to her and texted her, she had the copy of the text, that she has to notify me 30 days. And we were out of town. We broke our vacation early to come back and meet with her because I didn't want her to lock the keys in. I gave her the original keys. And so we went and did a walkthrough together. And that was on on July. I have to put 2 pairs of glasses on. It was on July. Where? Show me. Yeah, on 7/18, she sent or put a copy of the letter in my mailbox. And then on 7/24, we walked through together. She told me she was going to be out. And so there was a big storm that day and we left early. I explained to her that I would get back with her and we could get in the house because there was missing screens and different things that we pointed out during the walkthrough. I received a letter on the 27th.
All right, well, let me stop you.
Okay.
So she vacated, you did the walkthrough on 7/24.
Your Honor, it was 7/26 we did the walkthrough. I vacated on 7/24.
All right. Okay, we'll use 7/24 as the date. Did you turn in the keys?
Yes, on 7/26 after we completed the walkthrough.
All right, then that's the date, 7/26, turned in keys. And did you give your forwarding address in writing?
I sure did.
All right, that triggers their responsibilities. Did they send you a security deposit notice of why and how they intended to keep your security deposit?
No, Your Honor. The first time I saw anything was the papers they submitted to you.
I contacted her by phone.
She did. She contacted me on September 9th wanting to do another walkthrough. I told her another walkthrough is not going to work for me. because we had already done one walkthrough. She got defensive.
All right.
I told her that we can go
So
to court.
turn in the keys, give your forwarding address 726. You don't have to do another walkthrough. They have obligations under the Landlord-Tenant Relationship Act before they can keep your deposit. So they didn't follow any of that, and they didn't return your deposit or tell you why they were keeping it.
Yes.
Nine six. She hung up.
All right. So you filed this action on September 15th.
Yes. I did send
Now,
her
when she wanted to do another walkthrough, did you say, hey, where's my security deposit?
I told her another walkthrough was not going to work for me. It had been over 30 days, and I did ask her where the security deposit was. She got defensive. I told her we can take it to court then. I wasn't going to fight with her.
The landlord is held to a higher standard than the tenant. They're expected to know the rules, and there are violations for not complying with it. But what I'm struggling with is how much the actual security deposit was. Ms. Standish, how much was the actual deposit?
The deposit was requested not by, I didn't get anything from the shelter. I only got last
Well,
month's rent.
what does the lease say the deposit is?
I waived it.
All right.
I waived it. They had me write up the new lease and waive the security deposit so she could rent. She had been waiting from November. So I did waive it, and she was already approved to move into the house. And she had already done a walkthrough. So I waived that $500 security deposit. But when the shelter quit paying back in April, I told her on March 17th, I texted her and said that if you want to continue, what's the word you said? If you want to continue renting per the lease, we will, she would be required to pay a $500 deposit. She did pay that, but she paid $540. And I didn't even, understand that why, but $269 that she's claiming as part of her deposit is first week payment of rent for April
22.
of 2023. Yes. And we broke that
All right.
down in the spreadsheet.
Okay, now, when she left, did she have unpaid rent?
She didn't give me but like a 4-day notice. And I explained to her we needed a 30-day notice as per contract. At that point, she's like, well, we got to go. And it was an emergency. I didn't want to hold her in it. And I understood her emergency, but we were not available to meet with her. So when we broke it, so I could come back from our vacation up north, I actually came and met her and we left again. So I called her on 9/6.
All right, well, stop.
Okay.
I'm asking you what color the car is, and you're telling me how to get to Cincinnati.
I'm sorry.
So let me ask, was there any unpaid rent at the time she left?
When she left, yes, the last month,
All right, which was what month?
July.
Your
But
Honor,
the
may I add
Keystone
something?
covered that.
Just a minute, I'll give you a chance to speak.
Okay.
So we learned that she left on the 26th. So how much was the monthly rent?
$1,100 a month.
And you did not get July's rent.
We got till up to the 24th. The 30-day notice she did not give us it would have been August rent. I'm sorry, I've got a lot going on and So August is what wasn't paid. She paid the last month that was paid by the shelter, covered that. So she doesn't owe that to me. She left me with unpaid water bills of $233, which I made a copy of in the filing. I texted that to her on August 20th, and I never heard a response from her. So we received another water bill for the same month of July while she was there, and prorated it based on how many days she was there. And that's where the other $60 came in. And then just the damage, but she owed no rent.
All right. Well, you'd never sent her a notice of why you were keeping her security deposit.
I called and I texted her, and I never heard another thing. When I called her on 9/6, explained to her that, hey, listen, I'd like to do a walkthrough so you can see what's going on. She hung up on me and said, I'll see you in court. We never had a conversation. I was confirming the forwarding address to send a letter to her that was the same breakdown we sent to you for the filing.
There's a famous landlord-tenant case in Michigan. The name of the case is Havanesian v. Nam. And it says, well, this is what the rule says, and then I'll tell you what the case says. If there is damage to the rental unit, unpaid rent, or unpaid utilities, the landlord must mail an itemized list of damages or charges to the tenant within 30 days after the tenant's termination of the occupancy. The list must contain an estimated cost of repair of each property item and the amounts and bases on which the tenant is assessed. The notice must also contain a 12-point boldface type statement of the tenant's obligation to respond to the itemized list of damages. So you didn't do that. You didn't send them the security deposit notice. And the law says strict compliance with these notice provisions is required. Where a landlord did not send the notice but notified the tenant over the phone that the deposit would not be returned, the landlord forfeited his or her right to the deposit. And the Havanesian versus Nam case says, if the landlord is not aware of the tenant's termination of occupancy, the 30-day period does not begin running until the landlord learns of the abandonment. But in this case, you knew about it. If you did not send the notified list of intent to keep the security deposit within 30 days of learning of their moving, you forfeit the right to the deposit. Strict compliance with these notice provisions is required. So you owe her the deposit. You forfeited your right to claim it for rent, for damages, for unpaid utilities. The question is, how much is the deposit? What Keystone paid is not a deposit. And it's not her money anyway. She would get a windfall to get that money from Keystone. She did pay $540.
That is correct.
And she's entitled to have that returned to her. Your counterclaim is also denied. Now, I've talked to you about this before. You've been in the landlord business for a number of years. The rules are all about to change on November 6th. The Supreme Court has issued a new court rule regarding landlord-tenant cases, and it changes the obligations for landlords. And there are some things you have to include in your filing. When I get the information from the Supreme Court, I'm going to meet with the Landlord Tenants Association at a meeting and bring them up to speed on the changes. They're complicated. In fact, the judges don't all understand them yet. But this law has been in effect since at least 1995 and probably much longer than that. When she gives you her notice to leave, and turns in the key and gives her forwarding address in writing, you have 30 days to file that, which you did not do. I'm not going to give her the windfall of $1,600 of Keystone's money. Plus, your argument is that was not a deposit. And the $249 was not a deposit. That was partial rent. So, Ms. Honer, you're entitled to $540 plus $83.50 in court costs.
Okay, Your Honor, can I say something?
Yes?
Keystone did tell me that they made that $1,650 deposit on my behalf, that she did have to give it back once we were done with this. If you, that would come back to me. They said that you can go ahead and call them if you'd like, but they couldn't give me anything because her financials were on the paper. They said that they could give it to you, but not to me, stating that she pays that back to me. I do have the lady I spoke with's name, if you'd like that. I have to find it.
Well, this is the trial. And
okay.
We don't just call people up on the phone generally and say, hey, what do you know? We have in the past, but of your money, you're out $540. She also claims that was not a security deposit. There was something else.
Your Honor, I did share with you a screenshot of text messages between us, and she said in the messages, the 17th weekly rent is due of $269 per week. To make up the deposit difference, Keystone didn't pay. I said, didn't Keystone pay up till April 1st? She said they paid March, but when you moved in, it was $2,000 deposit, and they only paid me $1,500. I did include that.
Let's take a look at that.
Okay.
What's the date of that?
That is March 9th, 2023. Sorry, I muted. My kids just got home. I didn't want them to be loud in your ear. Also in these papers, there's a formal letter.
Don't get ahead of me.
I'm sorry. No, go ahead.
That's their answer. Since March is paid and we go by the week, we'll figure out a new lease for you and what your weekly payments will be. All right, that sounds good. We have to sit down and talk. The 17th weekly rent is $269 per week, and that's where that other amount comes. Hope all is well with you. They paid March, but when you moved in, it was $2,000. deposit and they only paid $1,500. So Ms. Standish, in that case, you refer to a $1,500 deposit made by Keystone, not something else, but a deposit.
Your Honor, I have
Yes.
horrible sight and I talked to text. So we called and talked to her because she was afraid that I was going to make her move. I said, absolutely not. They have been doing, good. They haven't had any issues. The issue was that they never were late. Cassandra was never late, but Keystone was horribly late. And
Well, that was very common.
well, I just want to let you know that I called her back and said, they didn't pay a deposit, but that's why I'm asking you to. I waived that. So when we talked on the telephone, I clarified that because they paid the $1,100 for the last month's rent, and they paid the first month's rent, and they paid the $500 non-refundable cleaning fee.
I don't have record of this phone call.
Keystone called me Wednesday of last week and said that Cassandra Honer was here saying that I was going to sue them. And so they called me and said, what's the deal? Because I have 4 other clients. And I said, I'm not suing you. And so I explained that we had a confrontation over the $1,650. She said, I will email it to you. I literally got it today, so I can't forward it to you. But that $1,650 was not a security deposit. They marked
Now,
it
this
like
check
that.
from Keystone Place says SD security deposit.
That's right. And
222 of 22.
that is correct. That's what it says. And that's why I called Keystone and asked them, you made me waive it. I've got the paper where I had to waive it. And she said, take it out of that fund. That's what they said. That's why it's marked that, but it was not. She said, we go by your lease, and your lease was $1,100 last month's rent and a $500 non-refundable cleaning fee.
That is not what Keystone told me. I got different information.
Well, one of the problems is whoever is at Keystone is gone. So whoever you were talking to back in February and even July is no longer there. The director is gone. There's a new director. And the people that were doing this is gone. But the check seems to call it a security deposit, and you call it a security deposit. It was $2,000 deposit, and they only paid $1,500.
I did see an attorney on our lease, and the lease spelled it right out for them.
Well, it would be great if I had a copy of it.
I know.
Your Honor, we also texted about it when we decided we were going to move. I asked her, I said, isn't my last month's rent paid through you guys from Keystone according to the security deposit that I have on file? And she said, no, there's nothing in the lease stating first and last month's security. And she said that I had to have the house clean and in ready move-in condition for the next tenant. When we did the walkthrough, she complained of dirty ceiling fans and the missing screens.
There's a non-refundable cleaning deposit which can be applied to that. But
she sent me this massively long list of things that I had to do to get the house ready for the next tenant. Move in, ready, clean, and ready to go. So I don't understand why she would charge me a cleaning fee and then give me a long list of things that needed to be cleaned and ready for the next tenants, which I did. I cleaned the house. It was in good condition.
Where is this house?
It's in Three Rivers off Portage Ave. It is an old house. It's fallen apart. It's one of the reasons why we moved. She had people coming in, and Scott had told me that someone was looking to invest to bring it back to its historical point.
Oh yeah, this house has been a subject for problems for a long time.
It was the moldy walls were making us sick. My daughters both had surgery because of it.
Yeah,
it's just we had to get out. And she was told by Keystone before we moved in, she was to fix the wall. We talked a year after we moved in. She told me she'd come fix the wall. She told me to put bleach on the mold, which you're not supposed to do. I did it. We all got sick. I asked her then again if she'd come fix the wall. She did not. And the wall, until the day I moved out, I have pictures. The wall was still not fixed. She hadn't come in and done nothing. I scraped it multiple times.
Now,
I sanded it.
under the new law, Mr. and Mrs. Standish, you're gonna have to ver that the place is habitable. And I'm familiar with this place. Some of it looks okay and some of it looks terrible. And I don't know, apparently it must have passed inspection from the city of Three Rivers.
We have the
But
inspection papers that we got also from the shelter. The shelter goes in and inspect before and after. There was
All
some
right.
damage, but we didn't get notification, which says in the lease if we have an issue. So they did a walkthrough in February, which I did not find out until after, but they called me yesterday, Wednesday of last week, and that's how I got this information because I didn't even know.
Who is they?
The Keystone.
All right, well, who, did you talk to a person with a name?
I did. Cassandra was just left the office talking to the same lady. Let me get her name.
Do you know where those papers are? Right there. I have her name too. Give me 1 second. I have a formal letter for you, Your Honor, if you need it, from them.
Well, yeah,
just
I
didn't
need
have
it. I
time.
need the lease. I need, everybody's
I
like
just
thinking that I'm clairvoyant or something.
I spoke with Caitlin Jackson.
Give me the name.
And Caitlin Jackson. And I also submitted with you proof from 7/6 of 22 in text that we talked about the moldy wall. And she told me to just throw some bleach on it. I told her I'd have it sanded. She said as long as we got some dry days, she'd be there to fix it. I submitted that in text. So she did know on 7/6 of 22 in proof that I can tell you right now that the wall was like that. And it was like that when I moved in. Keystone has proof of that as well. She was told throughout our whole year and almost a half stay that she was to fix these things, and she never did. Keystone was about to stop paying rent when they did that last walkthrough in February. They were going to withhold if she didn't fix these things, and then we no longer qualified, so they stopped paying anyways. I can scan these and email them to you if you'd like, all the papers I got from them. I just didn't know if I could submit them after, because 10 days ago, her her answers. I didn't, and then it says on the paper you have 10 days before court. I didn't know if I could still submit these, so I didn't do it.
I tried to save it. I can get it to him.
Can I go to that?
Yep. Yeah. I got the first, second, here. First, second, and third.
Let me try and email these to him.
Just a second.
Where's my paper? Your Honor, what email do I send these to? Is it the 3bcivil@stjosephcountymi.org?
Yes.
Okay, give me 1 second. I can go ahead and send that over.
Their new director is Anita, and I don't know. Ms. Standish, do you know who you talk?
Sorry, your call cannot be completed at this time. Hang up and try your.
I spoke to Anita. She was boxing up papers from Constantine and said that she would gladly pull it. And then the call Wednesday was from another girl. I thought it might have been Caitlin, because it was Caitlin or Christine.
Keystone, this is Christy. How can I help you?
Hi, this is Judge Middleton calling from the courtroom in Centerville.
Hello.
I'm in the middle of a trial, And I could use some assistance if either Anita's there or Kaylin Jackson.
Hang on one second. Can you please open up the door and let Anita know she wants to answer the phone? All right, I'm gonna go ahead and transfer you over.
All right, thank you.
You're welcome. Is she going to her phone? This is Anita.
Hello, Anita. This is Judge Middleton. Congratulations and condolences on being the new director at Keystone. We're in the middle of a trial involving Cassandra Honer and Robin and Ronald Standish. Anyway, I need some help. And there's a question about how much was the security deposit and who told who what. If I send you an email to your Anita at Keystone, will you join it and join us on the Zoom call?
Is it right now?
Right now.
I have a client sitting in my office right now.
All right. Do you even have any knowledge about this?
I feel like there was some issues going on. Cassandra saying that they were trying to take her security deposit. We don't request the security deposit back. If we've given it to them, they typically give it to the client. So if there was something going on with the client where maybe they did damages and they didn't return it, but we don't request it back.
We have a question of how much the security deposit was.
Okay, let me see if I can, if you have a second, I can try to.
Ms. Honer claims it was either $1,500 or $1,650. The Standishes have a different view.
Okay, do you know when she moved in?
February of 2020.
Oh, okay.
22 or 22?
22.
22.
Okay, let me.
Your Honor, when I talked with them, I explained, why did you call it a
Stop.
security?
I didn't
Okay.
ask you a question.
Okay.
I'll
Okay.
give you, I just want to focus on this answer and then I'll give you a chance to respond.
Sorry, our system takes.
You don't need to apologize. It isn't like I gave you a lot of notice here.
Okay.
They had an email from them right after she called me, and I'm trying to find it. And I don't know who it is, what her name was. But
Ms.
I have the
Standish,
email.
will you stop talking, please?
Oh, I'm sorry. I was.
We're still on the record.
How do you mute?
Okay, security deposit for, in behalf of Cassandra Honer was $1,650. And that was, paid on 3/4, the check date was, and the check was 19244. And that check has cleared through the bank.
I've got a copy of that check. Ms. Standish claims that it was not a security deposit. It was something else.
What else would it be? Because we don't pay.
First and last
security
month's
deposit
rent
or
and a non-refundable cleaning fee.
The only thing that we pay is security deposit and rent. That's the only thing that our grants allow us to pay.
All right. Now, I know who you are, but I didn't identify you for the record. So would you state your name
Anita Harper,
and your current position at Keystone?
director.
And how long have you been there?
I've been here for a year, but I've been the director here for 2.5 months.
And I always had a good working relationship with Keystone. They're no longer our HARA, as you know. I guess you're back on focusing on providing housing for people at the shelter, but I always enjoyed everybody that worked there and they were very helpful to me. Anita, would you raise your right hand?
Yes.
You swear or affirm any testimony you just gave to me was true to the best of your knowledge and belief?
Yes.
All right. Thank you for your help. I wish you good luck. Maybe we can talk about anything we can do for you. I have not yet met with the new neighborhood association, who is our HARA, but we'll work on that. All right. Thank you for your help and thank you for taking me on this immediate
You're
phone
welcome.
call. All right.
Have
bye.
a good day.
Bye.
Bye-bye.
All right. That's what Keystone has to say about it. Does anybody else wish to say anything? Ms. Standish, you had some things you wanted to say.
Yes, Your Honor. I spoke with Anita the other day, but they said they go by the lease. I explained, you marked it as security deposit, but our lease waived our security deposit. And Cassandra put in in her filing, the Keystone Place adjustment notification letter. That is the same thing I signed that waived the $500 security deposit. They paid last month's rent. That's why she didn't owe any, because she did not give me a 30-day notice. She gave me a text and like 4 days. The second part of that was the 196 was, they asked me, we weren't going to even start renting till March. She was desperate, and Cassandra was desperate and calling me, posting stuff on Facebook to move in that early. We let her move in on the 22nd of February. And they said we can pay her first month's rent prorated, last month's rent, and the $500 non-refundable.
That's what you called it. Keystone wouldn't have paid that.
Huh?
Keystone would only pay a security deposit. So you called it something in the lease, but as far as Keystone was concerned, that's a security deposit. And you accepted that money. And Ms. Harper confirmed what Ms. Honer said, is the tenant gets the money. You don't like this result, but let me repeat, the landlords are held to a strict standard. You've been a landlord for 20 years or more, and you don't understand the Landlord-Tenant Relationship Act or the Security Deposit Act, and you're strictly bound by the terms of it. In fact, in some measures, you could be ordered to pay 3 times the amount of the deposit. She didn't plead that. But as far as Keystone is concerned, that was a deposit. Then you took another $540 from her. So the total is not what she says it is, but it's $1,650.
Then she owes $1,100 in rent for the last month because she did not pay that.
But you never sent her a security deposit notice that said, hey, we're keeping your deposit because you didn't pay the rent. So that's the fundamental thing that you don't understand. Careful. In order to have me do this, you have 30 days to give her the security deposit retention notice under the Landlord-Tenant Relationship Act. And you didn't do it. And she's right. You owe $1,650 plus $540 is $2,190 plus $83.50 in cost.
Your Honor, may I add something?
Yes.
I will never be nice to
If you look at the date of the makeup security deposits that I had given you, I paid that $269 on 3/27, so it was days before rent was due. Rent wasn't supposed to be due until April 1st.
I paid it on. You get $2,190 plus $83.50 in court costs. Mr. and Mrs. Standish, you don't like this a bit, then educate yourself on the landlord-tenant law. And the rules are about to change on November 6th. and you're gonna be bound by them. And so you should either get some legal help or come to the session that I'm gonna have with the landlords. Or probably both. But the law says you have to respond when she turns in the keys. In fact, you never responded. A phone call or a text are not sufficient. It has to be in writing with a breakdown of the accounting. And the landlord is held to a strict standard. I didn't make this up. So I find for the plaintiff in the amount of $2,190. Keystone confirmed that that money inures to the tenant, not back to them, plus the $540 she spent herself. Total is $2,237.50 that you owe to Ms. Honer. You may think that's grossly unfair, then play by the rules or get out of the landlord business. All right, I'll send you a copy of that judgment.
Your Honor, can I have one question?
That's all. I don't have any more to say about it.